Yes, welcome to the No State Project live from the fortified compound in Mesa, Arizona. I'm glad to be back. Glad to be back. I think we're back. Appreciate anyone tuning in for the big broadcast today. Not going to give the number out just yet. Doesn't seem like we have people filing in. But it is episode 95 of the big show, live from the fortified compound in Mesa, Arizona. Glad to be with you here. Now, I have this shirt on. And before any lawyers who see the podcast, see the video, start getting freaking out and start talking about, oh, here he is trying to be a lawyer. Now he's pretending. Oh, stolen valor, which I have been accused of before, not regarding going to law school. I've not been to law school. I'm not pretending to be a lawyer. Just so you can see. Yeah, I see. It's a joke. It was a gift, so calm down. Not pretending to be a lawyer. It's just a shirt. So anyway, one of the things I wanted to get to before we start getting to the calls is some comments and answers that were given to me by bureaucrats in the last week, and these are tax agents in particular. And, of course, because I'm not making any IRS calls, since the government shutdown, you can't get through to the IRS. They're not working, which is good. But before I get into this, those who are thinking, hey, the government shutdown's great, the IRS isn't there, the computer is still on. And the computer is going to continue to escalate things against people. So the government shutdown does not include shutting, as far as I know, it doesn't include a shutdown of IRS operations completely. I could see, and I would definitely be, hey, it's great, and I think it's great that the IRS keeps, having, workers laid off, and their budget is cut, and for whatever reason, great, and that there's less of these people out there to steal from us, great, but we can't. The computer is still spitting out form letters, everybody. So that's kind of the fly in the ointment there, so you can rejoice. Government shutdown. The tax agency's computer still grinding away. So it's not the wonderful thing that you may think it is. So if they actually went to Ogden and pushed that off button and turned that damn computer off, hey, now we're getting somewhere. But not so much now. So I'm talking with a tax agent, and it starts off pretty good. This is property taxes, and it starts off pretty good because the agent we were calling to follow up on had burned some bridges. Not only did she not respond to us, which we kind of expect that, but she abruptly left the office, so the new tax agent that came in, not happy with the way the other tax agent left. So figured, hey, this is just one we get off the docket. So I always do things the same way. This is why I'll talk about this. The other case that we talked that I spoke on with the agents yesterday was so. I'm trying my best when I do these calls to not come off like a douche. Because I don't think I do, and that's not my intention. I'm trying to resolve a conflict. I'm trying to bring out that, by their own admission, they don't have any evidence, and the right thing to do would be to drop it. You don't continue going after somebody when you don't have any proof of your claim. But I know how it can come off. I listen to the calls, and we do the call of shames, and for the uninitiated, people who are not familiar, especially with these guys yesterday, it may seem like I'm just trying to get into a catch-ya and trying to be a, condescending, arrogant jerk. It's not the intention. It's not what I'm trying to do. And I certainly hope that that's not your intention if you are going after and looking at the, I got to turn that on so I can see. We should always be acting in good faith and treating them professionally the way we want to be treated. We have a conflict to resolve, yeah, but we don't want to come off as an arrogant blowhard. So I do things, pretty much the same way. before you can challenge somebody on their position, their argument, or their claim, you got to know what it is. So that's what I did. I told her about the previous agent, asked her if she agreed, since this is the way taxes and the way governments operate, do you operate under the presumption that if the property is physically in California, that your constitutional laws apply, giving you jurisdiction to appraise, assess, and collect a tax on Mr. Smith? And of course, she says, yes, of course. Yeah, that's the way. That's the way to, and that's a regular part of the of your job. You do that every day. You apply the Constitution and laws to people because you believe that just because they're in California, it all applies and gives you jurisdiction. So she agrees. Yeah, that's the way it's supposed to work. That's what they tell me. So I start asking her questions. You all, most people listening, except those new, where I'm going to follow up to this. I want to know if they have any facts. Now, I know that there are a handful of trolls, people who say that no evidence is necessary to prove that claim. Well, when you have a prison system and you're forcing people to give you money, then you really don't. That makes you a criminal. But you can't at the same time defend them as being a valid or legitimate organization. Defend them as the criminals that they are and say, well, criminals don't require evidence. Because otherwise, people of good faith, people who are acting in a legitimate, professional manner, if they make a claim, yes, they have to provide evidence. And I don't accept this, that they are somehow special, that the rules of evidence, the rules of logic and reason don't apply to them. Okay, that's why we talk about being an anarchist, that, no ruling class, because people believe that they're exalted, that, they're government. Logic doesn't apply to them. Evidence doesn't apply to them. No, you're an idiot for even thinking that. Well, abafongul, that's what we say. That is the only professional response, like a Harvard law response. If someone says that they can make a claim against you, and they don't have to actually prove it. But see, and this is the other side of that. Not only do they not have to prove with any evidence whatsoever that their claim is true, if you want to show that it's false, I need to have proof. That's completely backwards. I'm sorry, the burden of proof is on the one who makes the claim. And you don't get around that just by calling someone an idiot, calling someone a scammer, when they actually want proof of your claim. So beware of that. There will be people who claim to be very smart and they have advanced university degrees, and they'll actually say with a straight face, while calling me and some or another anarchist a scammer, the claim that the Constitution and laws apply is absolutely frivolous. If it requires evidence, it requires no evidence whatsoever because it's an issue of law. That's not true. I don't want to spend too much time on that unless someone calls and wants me to discuss that. Yes, Tom, you're absolutely right. Normal people, okay, non-criminal, normal thinking people who are being honest and acting in good faith, no. That which is claimed without evidence can be dismissed without evidence. The burden is on the one who is making the accusation. That is so simple. But when you're talking about legal land, when you're talking about lawyers whose mouth is firmly on the ass of the government, and then by men, and they're just men and women, that if a judge says it, it is like coming down from Odin Almighty. Odin's people, they don't need evidence. Bull. It's why they have a prison system to enforce their claims, because they're criminals and they have no proof. So, knowing this, I asked for my follow-up, which I want facts to support the claim. Why they believe their claim is true. So what she said, and I know I touched on this briefly on the Saturday show, but it dovetails in nice with the phone call from yesterday. This is a direct quote. I take notes as I'm doing this, which I always recommend that you do. You just have to put the highlight and what's really important and what they're saying so that you can bring it back. Because once you ask for the facts and they're not able to give you that, they're going to do it knowing that they can't do that. Knowing they're not stupid. They're not stupid. They know that fairness and due process requires evidence. That just making claims with no evidence it just doesn't cut it. A damn police officer is not allowed to even give you a damn traffic ticket without probable cause and reasonable articulable suspicion. He has to have some probable cause to stop you. And to think that issue of due process, it doesn't apply to the very foundation of the prosecution's case. The very foundation, it's just the relevance or everything else. No, this is a sacred cow and you just have to accept it as true. Well, idiots just accept things as true without wanting proof, especially when it affects their life, liberty, and property. So trying to get an answer as to the facts, this is what I got. Two answers that I got. I don't know. That's a good one. If you get that, good on you. She actually said, I don't know. Just like the cop up in, with Jermaine's case, when he got to ask for the facts supporting their legal claim that the laws apply because you're physically in Canada. I don't know. This is a good position for us to be in when our argument is you don't have any evidence and you're acting in bad faith because you won't drop it. Then she said, when pressed a little further about that, knowing, and I think she's like, I don't know is not really a good position to be coming from, especially when I'm trying to take thousands of dollars from somebody. She said, I would imagine. And what really got to her was when she insisted that she was right. See, this is like a reversal. They'll say to me like they did yesterday, they'll say, Mark, I don't think I can convince you. Well, you show me the evidence and you can convince me. This is a matter of where no matter what I say, even if they admit that there's no evidence, nothing will change their mind. It's not that I'm closed-minded and that I can't be convinced, and I won't accept the evidence. I do. They don't want to. So she gets all in a snit. Well, if you're going to just nitpick in every little word I say, no, I'm not nitpicking every word you say. I said, I'm trying to get your position clear here. Do you believe you are coming from a position of strength? And that you're supporting your claim against Mr. X, a claim to take thousands and thousands of dollars from him, when by your own admission you said, I don't know, and I would imagine. Now, does that sound like a strong position to you? That's as far as we were able to get. She wanted it in writing. And she started, I don't even understand your position. And that's what happened yesterday. Another property tax in California. And even though it was prearranged to be able to speak with counsel, they would not allow me to record. And they lied, I think, by stating they don't even know my position. How could you not know my position? I've already said it. My position is this. You guys don't have evidence to support your claim that just because the property is physically in California, that your laws apply and give you jurisdiction to tax Mr. X. That's my position. The facts are, we've made 2 calls prior, and each time when I asked Mr. Walsh, when I asked him for the facts to support his legal claim that he admitted he was making against Mr. X, he was not able to respond and was very uncomfortable and did not want to speak without counsel, which is why we are here today. So now that you know my position, may I record? No. So here again, they didn't want me to record. So this is one of the things that he repeated several times. And I think, because he sounded like a very intelligent guy, I was speaking to 3 guys on the phone yesterday. And it was the chief assessor, their counsel, the county council, who, by the way, said he was not a lawyer, but he was counsel for the county, and that his expertise is in helping to represent and assist the county in legal matters. The other one, I can't remember exactly what his position was, but he was also a county official with the assessor's office, I believe. So on more than one occasion during this phone call, and I have my notes to that too, he kept on saying he didn't know my position or what my argument was. So I had to keep telling him. And when it came to them not having any evidence to support the claim, so just watch out for that one. That's just one. That's one. I don't get your claim. I don't even understand. I don't even know what you're arguing. Okay, let me explain it again. It didn't matter because he just again said that he didn't know what my position was. When he knows the position and we start talking about it, and I'm asking for the facts, he said, well, that's your opinion that there's no evidence and we're acting in bad faith. I said, no, it's not my opinion. It's the only reasonable explanation given the facts. The facts that we have so far is when Mr. Walsh is asked directly for evidence, for facts supporting his legal claim, he wants counsel present and doesn't answer the question. Those facts is taken as true, which, of course, no one is disputing that. They didn't dispute it on the phone yesterday. Shows that, one, the agency cannot support their decision. They want counsel present. They cannot do it at this time. Two, knowing they couldn't proceed. I mean, knowing they had no evidence and knowing, or that they couldn't articulate any evidence and make their case, they proceeded anyway. Now, proceeding, knowing you can't make your case, is bad faith. So it's not my opinion it's in bad faith. That is what the facts say. And so questioning this guy, and the only answer that they were able to give was Article 13 of the Constitution. Oh. I said, again, we're asking leading questions. So I asked him, aren't you assuming your premise is true by going to the Constitution? I mean, aren't you already assuming the Constitution applies to go to a particular section? I didn't want to bring out circular, that the Constitution applies because the Constitution says so. I try to avoid using that because it's really offensive. Not that it is offensive, but it comes off. That's the response that we get. So I try to avoid doing that and say, well, isn't that a circular argument that the Constitution applies because it says so? So I try to avoid that. So then he refuses to get into that by trying to reframe my position. He said that I was arguing that the Constitution isn't real. No, we know it's real. It's a written instrument. You're trying to get around the question. You want to avoid answering the question. So I try to give him an analogy. If you're going to accuse, I know I go through this a lot. Are you going to, if you accuse me of violating the rules of the Olympics, do we just assume the rules of the Olympics apply and then go to the particular rule that you think I violated? Or do you first have to prove that the rules of the Olympics apply before you go to a particular section? Now, I know he had to have gotten that. So I had to ask again, isn't that what you're doing here? Aren't you assuming the Constitution applies and then going to a section of it? That's exactly what he's doing. So really, I said, aren't you just restating your claim? You're just restating your original claim that if he's physically in California, the Constitution applies. What facts actually prove that? Again, I don't care about these handful of trolls on the internet that say that's a stupid thing, that laws don't require evidence. We're reasonable, rational people. You don't get to say that you wrote something down on a piece of paper and it applies to literally everybody in the world without having some proof. I don't accept that just because you can put me in prison, that proves your claim is true. I don't accept that you put other people in prison, that's evidence to support your claim that a written instrument applies to me because you said so. So we're at an impasse. I'm going to have to follow up in writing and lay out what the facts are. And now we have 3 phone calls, and on all 3 calls, 2 of them, the main witness wants counsel present. When counsel is present, the best that they can do is cite the Constitution. They can't show any evidence that it applies in the first place. This is not political philosophy. We're talking about real, living, or not real, objective, written instruments that someone is saying applies. Not only it applies to you, not only applies to me and you, but creates obligations on you. That is not political philosophy. You're taking a legal claim or a claim that someone's making and wanting evidence to prove it's true. And the people who are making the damn claim are saying they don't need proof. Now they tried to flip that on us yesterday. Well, what proof do you have that we're wrong, that the Constitution does not apply? Oh, I don't know. I have 3 phone calls right now where you've actually said you're not comfortable answering the question without counsel, and all you can do is restate your claim. You can't actually prove that it's true. So those are a few more things you want to keep in mind if you're talking to these people. And I don't know another way about just repeating what they've said and you have to kind of do that when you're dealing with someone who's exercising such bad faith and just won't confront the issue. So we got really close yesterday. He said, well, this is a very interesting question. Oh, I'm glad you're not just shooting it down like some loudmouth attorney on the internet. You know, and that so keep those things in mind. You always want to stick to the point. Don't let them off the hook. We don't want to come across as an arrogant jerk, but we have a job to do. We have an objective that we want to reach, and that is showing that these people have no evidence and they're acting in bad faith. And we can do that every time. Every time. And gosh darn, you've got them. When you've got someone saying they can make a claim, they don't need evidence. And I'm going to say this again. Anyone who says to you that jurisdiction is a pure issue of law requiring no evidence is not telling you the truth. Because even when it comes to citizenship, they want to say, but you're a citizen. Whether you're a citizen that requires evidence. Even if it's just one fact, it's not an issue of law. It's an issue of law and fact. When you make an application of the law, you're not talking about a pure issue of law no more. You're not talking about what the law says. You're not talking about what it means. You're applying it. It's not theoretical at that point. It's a practical application of law. It requires proof. So don't accept that damn sacred cow that, we're special. So, well, this particular legal claim, that's off limits. Why? We said so. Aber fungul to your lack of evidence and your excuses that you don't need any proof. That is where the criminals lie. That's criminal. Yeah. Well, I can make legal. Yeah, and I've mentioned this before. Do we get to make legal claims? Can we have the very foundation of our legal claim against the prosecution? Can we have that without evidence? We know full well they won't allow it. We don't get to make legal claims against the prosecution. And when they say you need evidence, how about fungul we need evidence? It's a pure issue of law, buddy. Double standard. Yeah, that's right. Double standards everywhere. And you'll always get that with these people. Oh, but Marc, no judge has ever accepted. Is it logical? Can anybody prove that these laws apply? Even if we take the issue out of the court. Can you do it? Well, we're not even talking about in court. Just as an exercise in logic and reason. Can you do it? Because the bottom line here is you can't. And that's why you've got these cheerleading lawyers and anybody who profits off the system. They're the ones who are going to turn around and say that you're an idiot or I'm an idiot for even questioning what they say. Remember, good faith, if you're acting in good faith and you're an honest person, no claims are off limits. You should be able to challenge without this gaslighting crap trying to convince you that you're crazy for even trying to challenge it. And that's why government and the state and politics gets compared to a religion. Because they want you to take it on faith. Look, it's true because we said so. Laws are different. Again, from Odin himself, right? All right, let's get back to the calls. Everyone's been patient.
Yeah, thanks for having me, Mark. I had a quick question I want to ask you based on my case. You sent me a motion to disqualify, which I forwarded to the court. And the Solicitor General replied with a certificate of disclosure. And the certificate of disclosure actually has a copy of the citation in it. And he had the police officer as a witness in it, and it also had an explanation of the code which they claim was violated. So that's what was sent to me. I think the question I want to ask is that considered as replying to my discovery or Brady pending my trial on the 28th?
I think it's a partial response. Did they have anything in there that they're using that actually proves that just because you're physically in Georgia that their constitutional laws apply?
Mark, I know these people I've never seen any evidence anywhere, so it doesn't exist. So they didn't put that in there.
Okay.
Yeah.
Well, real quick, did they say that the witness that they plan on calling that he has personal knowledge, and did they give you any kind of proof to show that he has personal knowledge of the matters he's testifying to, namely that the laws apply and you violated them?
There was no proof. They just put a copy of the citation, explanation of the violation of the code, and the officer as a living witness. And they also told me that they had video evidence of whatever the officer, whatever the officer forwarded to them, that they have it. So that's what came in the package from the Solicitor General. So I called the Solicitor General's office, and they told me that he will not speak to me and let me speak to my solicitor. So I had his number and his email. I've been calling every day, and I can't get him, and I've been writing every 3 days, and he has never responded.
So you do have a lawyer. So you have a lawyer that's defending you, assisting you?
No, I don't have I do not have a lawyer. I don't.
So
I don't have a lawyer.
Okay, so I'm going to have to assume, since there's no notice of appearance from a lawyer, that this prosecutor is just lying to you that he can't speak to. Now, I spoke about this recently, and it comes up. It is a common lie from these bottom-feeding lawyers, these prosecutors, that they cannot speak to you directly. The only time that is true is if you have counsel. And here, there would be in the record a notice of appearance, whether from a private attorney or from the public defender's office, and there isn't one. So he's just lying to you as a way to avoid having to deal and show good faith and work with you towards a resolution on this and to comply with his discovery obligations and Brady obligations. He's just lying to you.
Yeah, actually, the Solicitor General who replied, and when I called the Solicitor General based on the information I had, they told me that, he's the Solicitor General, he can speak to me. So let me go to the solicitor of my case. That is how they handled it and pushed me away and said, let me go to the solicitor. But Mark, the greatest worry I have right now is that since I filed in the motion to disqualify the judge, I'm kind of worried. How do I know if actually the judge is being disqualified before my trial day? Because I won't feel comfortable walking into that court on my trial and see that same judge sitting on that bench. I will not be comfortable with that. So how do I know if they are compliant and if they are going to change the judge?
There'll be a record on the docket. There'll be a docket entry where the judge has granted the motion to recuse himself, and they would have another judge assigned. They could just not rule on it, period, which is in effect denying it, and just surprising you at trial. Now, I will point out to you that these bottom-feeding lawyers, whether they're prosecutors or judges, this is a common tactic. Judges and prosecutors aren't stupid. They all have to know. They formally deny the motion to recuse themselves, that you have jurisdiction to maintain a petition for writ of mandamus in the appellate court, and you can stop the trial so that the appellate court can review the denial of the motion to disqualify. They know that, and so by not making a ruling on your motion, they're able to deny not only your motion, they can deny you a remedy to stop their trial.
Yeah, so Mark, so is it possible for me to stop this trial if the judge don't disqualify himself, and how do I do that?
You have to get a ruling on the motion to disqualify. That's why I'm saying if you check the docket, you may be able to you may be able to check the docket online. I don't know. A lot of courts do that now. You know, you've got to check that out. You can call down there. Again, if they pull it like look, this is like a lot of times what they do to Edwin when it comes to the motion to dismiss, and it's the same tactic. They say, well, they're not going to give you a hearing on the motion to dismiss, and the judge won't make a decision. They say, we're going to reserve decision for the day of trial, which is, again, I'm saying it a lot this show, it's Abba Fungul. You're going to get in here. We don't give a damn what kind of defense you have. Get your butt in here so that we can put on a little show so that we can satisfy the appellate court's appearance of due process requirement. Okay? That's what they're saying when they do that, and they could do the same thing here. And I don't know. I don't have anything to offer you. You know, I don't think there is any way we can stop it because you won't be able to maintain appellate jurisdiction, you know, for an interlocutory type appeal like what a writ is. You won't be able to do that if you don't have a formal denial of the motion. So that's their way of saying,
exactly.
It's just like what's going on with somebody on the East Coast. They're sitting on a habeas corpus. They set it like 6 months in advance. I mean, later for a hearing. It's astounding. So what do you do with that? Well, I'll just take it to the appellate court. You can't go to the appellate court because they're going to say you've got a pending. It's pending in the lower court. You can't go to the feds because you haven't exhausted state remedy. So this is why I talk about them being bottom-feeding lawyers, because they do these things because they're playing God or Odin. They're playing Odin, okay, with people's lives. And most of the time, at least with the people I'm working with, when they do these things, we're talking about non-violent offenders. They're not doing this. Oh, that's right. See, if you're a cop and you rape a child, or you're a cop and you're engaged in child pornography, the king's men, they always, for lack of a better, no pun intended, they get off easy. Someone just posted that recently.
I'm just going to fight and try, because if this same judge, when I asked him in court, am I presume innocence of the charges filed against me, and he asked me to shut up, and if I offer a word, he will put me under contempt for 20 days. He just shut me down like that in court. So if I walk to trial and see him, I don't know.
And for someone asking, I seem a bit annoyed. Look, I'm half Sicilian. It's the way I am. I talk with my hands in one eye. And when I'm talking about bottom-feeding type attorneys and the sick games that they play with our lives, it's, you get a little animated. And some people may call it a rant. I don't give a damn. But you're going to have to, but Edwin, the best I can do right now is you're going to have to check the docket online, or call down there, or you may have to go down there to check the docket and see if the judge has granted your motion, and let me know. Hopefully they're not going to play it.
I'll do so.
Yeah, hopefully they don't play this like I've been mentioning, where it's that scumbag move where they just run the clock so that they take away your remedy, because that is really a scumbag move.
Okay, I'll do so, Mark, and I'll keep you posted. I sent all the copies of what I'm talking about. I sent it to your Skype. The certificate of disclosure, I sent it to your Skype, so if you can see it right there.
Okay. All right. I'll take a look
Yes,
at it.
sir. Thank you so much, Mark. I'll keep you posted.
You're welcome, and I'm looking forward to it. Good luck.
Okay, thanks.
Prego, paisan. And a big prego to all our callers and listeners. Hey, I think we got our first call from Key West. I may be wrong on this. I missed that other area code badly the other day, but with cell phones and whatnot. But we got area code 305. You're live on the No State Project. What's your name? Where you calling from?
Oh, my name is Jackson. I'm calling from Fort Lauderdale, Florida.
Oh, Fort Lauderdale. Wow. Do you spend time? Are you also in Key West at times?
No, 305 is for Dade County.
Oh. Okay. Do you make it to Key West at all?
Yes, I have. I work some security, and we've gone down there. Yes.
So you're familiar with Duval Street?
No, sir. No, I'm not.
Okay. All right. Because the one a friend of mine who does, I have all the bumpers on the show, and he's a pretty big time musician there. I mean, the guy can play, and he plays a lot of gigs on Duval Street. So anyway, what can I do for you today, Jackson?
Well, I got a speeding ticket heading to one of my security jobs, and it was kind of weird because when I jumped from 595 to 95, and I got on the tow lane, I was driving around, 75 miles an hour, and cars were passing me. So I sped up and went past another car, and then the car was just on my butt for some reason. So I'm like, okay. So I'm just staying at 75. So I sped up to 80, like, okay. So I moved out of the way, and it went behind me. So it went from 115, like 120, 115, all the way down to 395. So it felt kind of weird because it's still on my tail. So I sped up, like, okay, I was going in and out of traffic. Like, why is this car on me? So I decided to pick up my phone, and I was about to call 911 because I pulled to the side and, slowed down. And the car went past me, and it was actually a Miami-Dade cop.
Okay.
Or a Dade County cop. So then he put his lights on, and I'm like, okay, why were you on my butt? He was like, you were speeding. I was like, well, you were on my tail the whole entire time when I was going slower than the speed limit. He didn't say anything. He ignored me. So then, of course, he went to the Hostel license registration, gave it to him. And when I said I actually was calling the cop, the police, because you were telling me, he calmed down. So he gave me a ticket, and I definitely want to remedy it because it shocked me. He could stay on me for like, I say, over 100 blocks, like just on my tail.
Well,
so
I'm sorry that had
could
happened.
help me.
Cops. It's. I remember a number of years ago, there was I think 4409 did on YouTube, but it was, a thing about why cops are so hated and people love firemen. And it's like, do you ever think maybe it's because firemen don't drive around looking for for fires? You guys, you actively go out looking to make an arrest. Not that someone is, and I'm going to remind, since we're down it's in Florida, when it came time to actually pull a gun and use it against somebody who was actually a threat, what did the cop do? Peterson. What did he do at the Parkland shooting? He didn't go in. And now he's arguing.
Exactly.
And now he's arguing, I'm not there to do it anyway. Right? A big abafungal to everybody. And he's going to win because that's the law. So here, yeah, he's just it could have been a lot worse. It could have, something like this. It could have been. It's just a ticket. It's not like he didn't. Even on, if we keep it just in the realm of traffic, he didn't steal your car. He didn't leave you stranded there. So,
Exactly.
so that was good. So the way I look, he's making legal determinations, and that's why he stopped you. He determined that because he saw you physically in Florida, that the laws applied and gave him jurisdiction. Okay, that's exactly what he did, and he'll tell you that's what he did. Why else would he have pulled you over if he didn't think that the laws applied and you violated them, right?
Correct.
Right. So I challenge his ticket, his legal claims by way of a motion to dismiss, and it's based on, of course, a lack of evidence to prove that that's not even a prima facie level of evidence to support a finding of jurisdiction, personal, and subject matter. And I don't know how familiar are you with the material here?
Not very familiar at all. I'm a newbie, so I've been perusing your website and looking at different things. I know I've read up on the jurisdiction part of it and some information on how to set it up in court. Like I'm here today to do this and that, et cetera, et cetera. But I wanted more information so I can thoroughly study it, so I can be more confident. My court date is next Friday at 8 a.m.
8 a.m. next Friday. Now, is that an
The
initial
25th.
appearance, or is this a trial?
Appearance.
So, did he charge you with a misdemeanor?
Let me go get the ticket. Yes, a misdemeanor. It's just like traffic court.
Okay, so this is the time for the arraignment. Now, so the basics is what are important in knowing the foundations of logic and why we're asking the questions and why we're just asking questions, why that's so important. Why is it to your advantage just to ask questions?
To prove jurisdiction. I'm assuming to.
But what's the point? What's the point in asking questions? Why is it more effective for us to ask questions instead of just making statements?
To have a better understanding of it, I'm assuming.
Well, that's certainly part of it. But the reason why we want to just stick to asking questions like we're doing a cross-examination is because the burden of proof is not on us. If you make a...
Oh, that's right. Just going there.
Right, you got to keep that in mind. It is really important. You'll find out if you listen to a lot of shows where people have called in reporting about what happened in court, what they started doing most of the time was they weren't asking leading questions or they were making statements. So that's the difference when if you listen to what I've done, and I've confronted judges, I've confronted this Supreme Court Chief Justice here in Arizona. You ask a leading question. There's a big difference in the way I do it than when you hear some other people like Robbie, who's a good guy. If you watch that video, it's like 47 minutes long. He was not using the Socratic method. He was narrating. He was giving a narrative. He was giving his own explanation of how he sees the world instead of putting the police officer to task on proving his view of the world. Okay, so here when you get to court, they believe that just because you're in Florida, their laws apply to you. Okay, and they may argue with you that they don't even have to prove that. How could it possibly be fair if the foundation of their case, they don't even have to prove it? Now, does that sound fair to you?
No, it doesn't.
And due process, keep in mind, due process requires at a minimum, this is state or federal, even in Canada, Australia, at a minimum, notice and opportunity to defend. And that requires a hearing, a meaningful hearing, where you have the opportunity to question the evidence and the witnesses being called against you. Minimum. So, does it satisfy due process, and is it fair to have the prosecution be able to make the foundational claim to their complaint be one that you cannot challenge and attack?
Oh, no, I should be able to challenge and attack.
Hell yeah. So,
in addition to that, I saw one of your videos where you actually also questioned the police officer regarding, their their part of the case to I guess make them not necessarily lose their job, but you said if they lost their job that would be great, but question their not reliability or something like that, or
well,
something you said.
There's two general elements that go to whether somebody is qualified to be a witness against you.
Qualified.
And it has to be competency, credibility. Now, typically, competency is something that the judge determines. Credibility is what the jury determines. I think the jury can do both. But the judge is the one who is in charge. So the rules state very clearly and unequivocally, proof must be provided before the witness may testify that they have personal knowledge of the matters they're testifying to. Now, the personal knowledge can come out in testimony. However, as I said 1,000 times already, they are not allowed to surprise you. Now, there may be something, the extenuating circumstances, a witness, or you have a witness that, you didn't have time to put on the list, and there's reasons. But generally, they're not supposed to surprise you. So whatever proof the prosecution is planning to present to show that the witness has personal knowledge, they have to give that to you in disclosure. But before the cop even gets on the stand, a lot of the questions you would ask the police officer, because you're there because he's the one making the claims against you. The cop makes the claim. The prosecutor's job is to prove it correct beyond a reasonable doubt. The judge is there to determine whether the prosecution has done that or not. Okay? And so before that, the prosecutor is going to be making these arguments and trying to get the judge to agree that they're true. So you get to question the prosecutor and the judge on these things. So you want to do the role playing tomorrow. You got a court date coming up, so make sure that you contact me at Skype at Frank Rizzo 3, and we can get you into the chat. You can start working on that. We'll do the role playing tomorrow, same time as this, so that you can you can apply the basics. You want to look. This is going to help. You want to assume that everything the judge, the cop, and the prosecutor say is a lie. So that's a cue to you to object and have them prove it. So if they say to you on Friday when you're challenging jurisdiction, and they say, jurisdiction's a trial issue, what are you going to do? What are you going to say?
I would say object. I'm here today. I'm here to. My intentions are to plead guilty today, so I wanted to get this done. I was reading it, but I'm sorry, I'm not fully ready. But
if you know the basics, that there are just 6 types of questions: who, what, where, when, why, and how are going to really help you with your leading questions, which is all you really need to be asking these people. That will give you an idea on how to object and ask them effective questions. So, objection, jurisdiction can't. Please be clear. You're saying jurisdiction can't be challenged at this time, right? So, is the prosecution asserting jurisdiction? Then why can't I challenge it? And you can even use an example.
Wow.
So if I sued you, you would not be able to get it kicked out for a lack of jurisdiction because of sovereign immunity. You would have to wait till trial to argue sovereign immunity. Is that right? Is that what you're telling me? No, it's a lie. Jurisdiction, the moment it's asserted, you can defend against it. Jurisdiction is a trial issue. That's true. It's not a trial issue only. So you want them to prove that. Objection, cite that. Cite me where it says that jurisdiction is a trial issue only. You're not going to get a citation because he's lying through his teeth. You want to challenge it. If you're asking what facts did the prosecution present that prove their claim that just because I'm physically in Florida, your laws apply and give jurisdiction over me. And he says the ticket. The ticket. Sir, don't you the ticket. You should object and say, what on this ticket is evidence proving the Constitution applies to me? So what other people, like the trolls, the 2 or 3 trolls on my show, on my forum, they want you and I to believe that I am an idiot because I dare challenge that assertion. You can read it for yourself on my forum. I'm an idiot because I challenge that. They'll tell you jurisdiction requires no evidence. I'm going to quote it again for you since you're a newbie. Ray from Desjardins or whatever his name is up in New Hampshire. Jurisdiction is a pure issue of law. It requires no evidence to prove it's true. The only thing the prosecution has to do is prove you're physically in New Hampshire. Now, does that sound like a contradiction to you?
Yes.
Yeah, because if it's a pure issue of law, they don't have to show your physical location. See, that's the part that they have to prove beyond a reasonable doubt at trial. So, because it's an element of the charge. They have to show beyond a reasonable doubt that you were actually in New Hampshire that day. I don't think that that's sufficient. And I've even asked people like the Chief Justice of the Arizona Supreme Court, what facts prove that just because I'm in Arizona, what facts prove that just because I'm here in Arizona that your constitutional laws apply? The best he could do, not like this internet troll, is say that they put other people in prison. Now, the better follow-up question is, remember I told you the why and how? Exactly how does putting other people in prison prove your laws apply to me now? They're always spewing BS, Jackson. It's always a lie, and if you assume it is, you're going to object, and you're going to ask them to verify it, and you're going to ask a good leading question to bring out that what they're saying is nonsense. So real quick before I'm out of time, they'll say something you like, you have a driver's license. Now, what do you say to that? You're asking for proof that the Constitution and laws apply because you're physically in Florida, and to fire back at you, dude, you have a driver's license. I think we lost Jackson, so unfortunately, hopefully he will get us at the show tomorrow. We'll do the role-playing tomorrow, and we'll get back with Jackson. But just since you're listening, you can watch the video. When they say something like that, usually it's in the form of a question. Well, sir, don't you have a driver's license? Don't you have a license? Don't answer the question if they do that. You want to object and see, well, let me see if your position, if I got this straight. Are you saying that the driver's license is evidence proving the Constitution applies to me? But if they just say, dude, as an answer, dude, you have a driver's license, then you object. Objection. Exactly how does having the driver's license prove the Constitution applies to me? Well, that's what a trial's for. Really? You're going to allow the cop to answer that question? Yeah, sure. Well, you know what? I don't want a trial. I intend on pleading guilty. Tell me exactly how a driver's license proves the Constitution applies to me. Go, I'll wait. Oh, well, you're just an idiot for asking the question. You're an idiot just for even asking that. How dare you challenge us? That's the friggin' arrogance of these people. It's not me. I'm just making a challenge. Am I arrogant because I don't accept this crap that's been spewed forth for 200 years or more? And contrary to what they say, yeah, we have success, just like ICBM asked. Hey, how's that working out for you, challenging jurisdiction? Pretty good. Pretty damn good. We've got a lot of stuff thrown out. A fraction of it has been posted because I don't always get the documents. And I might talk about it on the show, but I don't post an article and a video about it unless I have the actual proof. So, just to summarize here, we stick to the basics. We do not accept sacred cows. This is not a matter of religious faith for us. We want proof. And it is not wrong, and it's certainly not bad faith for us to challenge us and require that somebody making a claim should actually prove it's true. So I will probably do a separate video regarding this, one of the few trolls, because it's a very lengthy response. And then you'll see in the video that I'm an idiot even for saying it. Oh, because no judge has accepted it. Well, that's not true. That's not true. And it's not even necessary because we can get things tossed out by effectively defending ourselves this way. And we've proven it time and time again. So just know when you stick to logic and you hold them to their burden, when they start arguing, I don't have to prove my claim, you know you've got your bad faith. You know you're dealing with a crook. You've got them. Doesn't mean it's going to get tossed out. I wish it did. But it doesn't. So remember, The fact not appearing is presumed not to exist. If they had proof, if they could prove their claim, they would do it. They wouldn't argue like that lawyer in New York that I've talked about before. They wouldn't try to make you believe that they don't have to prove it. They do. Don't surrender your intellect. Don't surrender your integrity. Question them. And don't let them get away with it. Hold them to that burden of proof, damn it. That's how we get these things tossed out. And that's why so many times we get a nolo prosequi. How many times have I posted prosecutors tossing out their own complaint because they don't have sufficient evidence? All right, we will be doing the role-playing tomorrow. You have to contact me on Skype to get the new link for Discord. I urge everyone who's going to court or wants to learn how to do this to participate or at least listen in initially. Do your sparring. And whoever I may have missed today, feel free, call. We'll do 3 to 5 on Friday, 2 hours commercial free, so that we can have the new content for the LRN.FM stream. So until then, everybody, salud.